Hello students, how are you? So in last previous lecture, we have talked about the corporate personality concept. I hope that concept is very clear to you. So in today's lecture, we will move further and we will discuss about the provision. Okay, what is mean by company exactly? What is the definition, okay, given under the Companies Act 2013. They will talk about very important question from exam point of view, that is advantages or features of company. So we will discuss in detail various features. One of the feature we have discussed in detail during our last lecture. So let's quickly revise what we have done in the last lecture. In last lecture we have understood the concept called as corporate personality. So there are various theories of corporate personality. There was fiction theory, bracket theory, purposive theory, realistic theory. So all these theories we have studied in detail. We have discussed the types of corporation, corporation aggregate, corporation sole. So now in today's lecture, let's first quickly talk about what is company. So far we have already discussed, but let's try to understand once again. Company. So what is company? So company basically it's derived from the Latin word. Okay, so there are two basic words, okay, from which the company word has derived. So here you can say it's a com and funny. So when we say companies, okay, so com means together, okay, it's a Latin phrase, try to understand. It's a Latin word, so it means together in English, and means bread. Now you'll be surprised, okay, why I have mentioned here as bread. In the olden days, in the past days, okay, people used to have gatherings together, and during the festive season they used to meet and discuss about their businesses, and accordingly this concept has derived. But in today's era, okay, we recognize this company form of business where people meet together and discuss about the businesses, and now it is a very structured form of business in comparison to the other forms of business entities. So company, okay, we have derived this word from com and pennies, that is the Latin word. But if we talk about the Companies Act 2013, okay, you will find the definition of the company under section 2 subsection 20. Okay, now this particular section 2 subsection 20 says that a company means a company which is formed and registered under this act or under any previous law. So company, let me just put it in the words for all of you. A company means a company say incorporated under this act, or under any previous company law. Okay, so this is very important definition. If the question is asked in exam what is company, okay, then you need to first answer that question with the help of the provisions. Okay, the provision is given under section 2 subsection 20 of the Companies Act 2013. So here if you read this very simple definition, you will come to know that a company means a company incorporated under this act. So can we have a company without registration? Answer is no. So it has to be incorporated under which law? Under 2000 under Companies Act 2013 or under any previous company law. So it may be a company which is registered under the 1956 old act. Then also our Companies Act 2013 is going to recognize that form of entity as a company. Okay, so there is no fresh registration is required for a company which was registered under previous law. So that is Companies Act 1956. So it will be automatically be considered okay under Companies Act, and all the provisions which are there for the companies which are registered under Companies Act 2030 will be applicable for all those companies which were registered under 1956 Act as well. Okay, so this is the basic concept of the company. Okay, we need to understand first. Okay, so what is company? This has come from the Latin word com and panis. Once again I am just revising. Okay, which means together and great. So there were gatherings happening earlier. People used to meet during the festive season, and over the dinner or the lunch, you can say, they used to discuss the matters. This is I'm talking about the olden days. But now in the new era, okay, we have a structure form of entity, that is company, which is recognized under the Act. So make a note of this very quickly before we'll move further. Okay, I hope you have taken the note of this particular definition. Now let's move on to the very important question from the exam point of view, which may be asked in the exam. Okay, which can be called as features, or you can say characteristics, or you can say advantages of company. Okay, so this particular very important question we are going to study today. Okay, this is very important from exam point of view, can be asked for the 12 marks as well. So what all features or are there, or you can say advantages of the company form of business? So we can start with the very important concept which we have studied in the last lecture. Okay, if you are aware, that is corporate personality. Corporate personality, or you can also call this particular concept as separate legal entity. Okay, students, this question can be asked separately as a short note, or that can be asked even as the 12-mark question. Okay, so I have taken the separate lecture on the corporate personality concept in my last session. If you are aware, I have taken one case law. So there are two case laws we are going to discuss in the corporate personality, which I have taken the one case law which I have already discussed during my last lecture. So the case 1 is going to be the very famous case, that is Solomon versus Solomon and Company Limited. This case law is of 1897. Okay, so no need to again discuss this case law as we have studied under this particular case law in just that company is different from its members. So company once gets registered, incorporated, then it gets its different legal status which is separate from its members. Okay, so very important case law from exam point of view. It can be asked as a 12 marks, as a 5 marks, whatever. Okay, short note as well. So second case law for your understanding. Okay, we'll move it further. It's Lee versus Lee's Air Farming Limited. So comparatively, this is new case. Okay, 1961. Now what happened in this particular case? Okay, let's try to understand. In this particular case law, Mr. Lee, who was one of the shareholders in Lee Farming Limited, now he wanted to do some business of aerial top dressing. And what is the aerial top dressing? Aerial top dressing is a kind of activity which was introduced in the New Zealand way back in 1940, way back in 1950 somewhere. Okay, that the fertilizers can be just put on the farmlands, okay, with the help of the aeroplane. Now Mr. Lee, who was the trained pilot, okay, he formed a company in the name of Lee's Air Farming Limited, which was there in the aerial top dressing business. Mr. Lee, once he became the shareholder, he was a kind of majority shareholder in the company. He himself appointed him, he was appointed as the managing director. Along with that, okay, since he was the trained air pilot, he was a trained pilot, okay, he was appointed as the chief pilot as well. Now there was a contractual obligation, or you can say the relationship which was established between a Lee and the Lee's Air Farming Company. Then because of that contractual relationship, there was a kind of relationship of employer and employee. So the business was going on, and at one fine day, okay, there was a crash of the plane, okay, and he was killed. Now the widow of Mr. Lee, okay, she claimed the amount from the company, or rather she claimed the compensation from the company, stating that my husband, okay, was working, okay, with the Lee's Air Farming Company as an employee. It was objected by the company because we have now understood there can be board of directors, there can be other shareholders as well. It was objected by the company, stating that Mr. Lee and Lee's Air Farming Limited was not different. So there was no such employer or employee relationship, and on that basis the contention was made by the company. But court held that, and the court took the reference of the Solomon versus Solomon and Company Limited, and court held that though there was Mr. Lee was the shareholder of the company, though he was the managing director of the company, but still he had entered into a contract with the company for being the chief pilot, and there was a kind of employer and employee relationship in that particular capacity. And that is the reason court was of the view that the compensation should be given to the widow of the Lee, Mr. Lee. Okay, so this is also one of the very important case law for your reference. Okay, you can just quote this case law, okay, if the question is asked during the exam. Okay, so let's talk about the second very important feature, artificial legal person. Artificial legal person. Now students, just tell me whether you and me, we are artificial legal persons or natural persons. Yes, we are natural persons. Okay, so what is mean by artificial legal person? So when company gets incorporated, it becomes in the eyes of law as artificial legal person. What does it mean? It gets the legal status. Okay, it is considered as a person, but it is considered as the artificial legal person and not as the natural person. Okay, so this particular concept we have already studied in detail in the corporate personality. With the help of these features, again we are going to touch upon the very important points of artificial legal personality. Okay, so because the company is having so many features of the person, like it can sue and be sued, it can have the separate property, it can have, it can enter into a contract. Okay, so all these features are applicable to natural persons as well. But there are some features like company is not treated as a citizen, which is one of the disadvantage of the company. We will talk later on, because only natural persons can be citizens of India. Okay, so with respect to this particular feature, okay, we can have one more case law over here. Okay, let me just quote that case law first. Okay, Union of India versus Khadar International Construction and others. Let me just quote Union of India versus Khadar International and other. This case law was of the year 2001, very recent case law. Now, what was happened in this particular case law? There is a concept called as indigent person under Order 33 of the Code of Civil Procedure. So, basically this concept is there that, okay, if a person who is indigent and is cannot afford to pay the court fees, okay, so there are certain provisions made relating to this particular such particular persons. Now in this particular case law, it was happened that the company said that, okay, we are indigent persons and we are not able to afford the court fees, and that is the reason, okay, we should be exempted from, or this provision should be made applicable to us as well. Now the question before the court was whether company can be treated as indigent person. Now after reading the provisions, the other party was of the opinion that company should not be treated as indigent person, because under CPC the provisions relating to the indigent persons are only given to the natural persons and not to the association of persons like company form of business. So this matter went to the High Court. Later on it was challenged before the Supreme Court, and the Supreme Court was of the view that the person which is mentioned under the Orders 33 of the CPC, Code of Civil Procedure 1908, it includes, the person includes natural as well as association of persons or the body corporates like company form of business. So we can say that, okay, with the help of this case law we can come to know that, okay, though it is the artificial legal person, so many of the features which are applicable to the natural persons, or you can say benefits which are given to the natural persons, can also be given to the artificial legal person. So this is one of the important case law. Let's move on. Okay, we have completed 2 features so far. There are other features as well. Okay, so we can say that when a company is a national company, has nationality, company has nationality. Okay, though company is not treated as a citizen, but company may have the nationality. So like we can say that with the help of various case laws, okay, but this point is not that much lengthy. Or so company may have its domicile, but we cannot say that, okay, because under the Citizenship Act, company is not recognized as a citizen, okay, but company may have nationality. We can say that it's an Indian company which is registered under Indian laws. So such type of nationality can be given to the company. So those benefits can be given to the company, but benefits which are given to the citizens cannot be given to the company form of business. Let's talk about the next feature, which is limited liability. Students, I feel this is one of the very important feature or characteristics of the company form of business. What is meant by liability or limited liability? So liability means the obligation. Now here we are talking about the obligations or the liabilities of the shareholders. So what kind of liability is there to the shareholder, and when that liability can be invoked? So take an example, okay, when you apply as a shareholder in the company, when you want to become the shareholder in the company, you have applied for the shares. Now the face value of the share, so the nominal value of the share is 100 rupees. And you have taken, let's assume that you have taken 10 shares of the company amounting to 1000 rupees of shares. Now for taking those 1000 rupees of shares, you have paid 500 rupees at the time of allotment. Now what is the balance figure? What is the balance amount? Okay, that is a called up capital, that is 500 rupees. Now at no point of time, if it is the limited liability, your liability will exceed 1000 rupees. That is a very, very important feature for the company, and that is the reason most of the people, they prefer to go for the limited, or they prefer to go for the company form of business. Okay, so let's take example. Okay, there is shareholder. Let's change the color. So there is shareholder, okay, who has purchased, let's assume that 10 shares of ABC Private Limited. Okay, 100 each. The nominal capital value of the shares is rupees 100 each. So what is the total amount of share capital he is holding? It is rupees 1000. Okay, now out of this 1000 rupees, he has paid 500 at the time of allotment. At the time of allotment. Okay, now what is the balance figure? That is 500. Okay, is the balance, or you can say called up capital. Called up capital for A. Okay, it is only for the shareholder. Okay, now what is the liability of, we can say that he is Mr. A, for your kind information. Yeah. What is the liability over here of A, if it is the limited liability? Okay, so liability over here cannot exceed rupees 1000. So once he has paid rupees 500, then his liability will only remain to 500. That is the called up capital balance amount. So at no point of time that liability will exceed more than 1000 rupees. Okay, so this is the limited liability concept. Okay, now here it is exactly given that the company is having the limited liability or not. Okay, there are concepts like limited liability, there are concepts like liability by guarantee or unlimited liability, but most of the companies you will find there is the limited liability concept. And company form of business is basically famous, or you can say popular, for this limited liability concept. So here the question will arise: if a company has been established or incorporated for fraudulent purposes, then also Mr. A will have the limited liability? Answer is no. Okay, so there are various situations where the shareholder intentionally, okay, has established a company for some fraudulent purposes, or provided some false information at the time of incorporation, and after knowing all the facts, and later on it was found that, okay, the shareholder was involved in such fraudulent activities, then his liability will be extended up to unlimited liability. Okay, this is the major point of difference between company form of business and partnership. In company form of business, the liability is limited, and in partnership form of business, the liability is unlimited. What is meant by unlimited liability? Try to understand that. If company goes, if let's say partnership business is there where A and B both are partners, if partnership goes for dissolution, if the assets are not enough, okay, to fulfill the liabilities of the company, then the assets, the personal assets of A and B, okay, and A and B will be liable, okay, for the personal assets as well. So the money can be recovered from the pockets or personal assets of A and B in that particular situation. That is the concept of unlimited liability. Okay, and because of this particular concept, okay, the company form of business is very, very popular. So I have already told you various exceptions, okay, relating to the unlimited liability concept and limited liability concept, and we are going to study in detail, okay, about those particular points, okay, when we will talk about the disadvantages of company. Let's move further, okay, with the concept of perpetual succession. What is meant by a perpetual succession? So if something goes wrong with the company, okay, or there is a meeting going on of the shareholders, and bomb blast happens, and because of that, okay, all the shareholders, directors of the company, they died in that particular bomb blast. Whether the company's status, the separate status what we were talking about, will be affected? Okay, so answer to this particular question is no. Okay, what we mean by perpetual succession? Okay, if we take the meaning of it, company is, okay, here we can say company is treated as going concern. Company is treated as going concern, because when the shareholders come into picture, okay, they are different because of this separate legal personality concept. Now company gets its own status, company can start doing the business, shareholders are not liable for what a company is doing, okay, that is what we have studied in the limited liability concept also. Now something goes wrong and the shareholders are no more there, it does not mean that, okay, company form of business will come to an end. Company form of business can only come to an end with the help of the winding up provisions. Try to understand, students. The company is created by law, and the status of the company can be taken away with the help of law only, and that is the reason the provisions are incorporated, okay, or provisions have been incorporated under Companies Act 2013 relating to winding up. So company may go for winding up, then only companies, you can say, existence can come to an end. Now what will happen if the shareholders are no more? Okay, the new shareholders will come and they will succeed, okay, as per the laws of succession. they will take the shares of the shareholders, deceased shareholders, and the new shareholders will come, the new management may come, okay, for the company, okay, and then that is the reason the concept of perpetual succession is very important. So you need to understand that, okay, company never dies. Company never dies. It can only come, the business of the company can only come to an end with the help of winding up provisions. So unless and until company goes for the winding up, maybe voluntary winding up or winding up by the court or various other provisions are there, company's life will not come to an end. Till that time, it will always be considered as going concern. Okay. Let's move further. I hope you're finding it very helpful. Yes. Okay. So we were talking about, I think we have discussed about 5 features. Okay. Now we are going to talk about next feature, which is separate property. What do you understand by this word separate property? It's a very simple feature to understand. Can company own, can company dispose of its property? Okay. Now the question will arise, okay, compared to the partnership form of business, where the property of the partnership is the property of the partners. Okay, of course it is the property of the firm, that provision is there, but when they purchase the property, it is in the name of the partners. Okay, that is not the case with the company form of business. Okay, once the company is established, it gets its separate legal existence. It is considered as the corporate personality. Company may own, company may purchase a property in its own name, company may dispose of property, or company may transfer the property to third party. Now this is a very important provision, and there are some connected points to it. Okay, we will discuss about that as well. So how company can do it? Okay, with the help of the next particular feature, we can say that there can be, or you can say there can be contractual rights. There can be contractual rights. What is mean by that? Okay, company can enter into a contract. So once the company gets established, company gets its own name, there is a procedure that company has to get the name, which should be very distinct. We should not resemble or be similar to the existing company's name. Okay, as per the ROC guideline, as per the Companies Act provisions, okay, we need to apply for it. ROC may grant the name or may allow that particular name. So once the name is given, okay, company can start entering into the various contracts. All contractual provisions, okay, which are given under the Indian Contract Act 1872, okay, will be applicable. Now the question will arise whether shareholder can enforce the contract entered into by the company. Answer is no. Okay, so shareholder is different, and once the contractual liability is there, it will not pass on to the shareholder of the company. Okay, so for all the contracts entered into by the company, shareholder may not be liable. Of course, there are certain provisions, okay, relating to the doctrine of corporate will, which we will discuss in detail later on. Okay, so this is a very unique feature, that company is different and the shareholders are different. But now the question will arise, company is an artificial legal person. How can company take the decision? Okay, so the decisions can be taken on behalf of the company by the management, that is the board of directors. The management is in the hands of the board of directors, because in the company form of business, the directors are treated as brain of the company. They are the decision making persons. Okay, So in that particular case, how the company can enter into a contract? Okay, the next particular feature, okay, we can study it. That is with the help of common seal. With the help of common seal. What is mean by the common seal? Okay, common seal is nothing but it is signature. Okay, signature of company. Signature of company. So try to understand, when a company is entering into a contract, okay, company has to sign. Now the signature is basically is not like a rubber stamp. Try to understand. There is a huge iron or type of one the signature which can be engraved on the document, which are used by the companies. Okay, but as per the Companies Act, for this is for just for your information, Companies Act amendment. I should small amendment 2015. Okay, this provision has been dispensed with. Okay, so now the companies, they do not require common seals. So whether does it mean that okay, company cannot enter into a contract? No. So company may enter into a contract, okay, as per this particular amendment. See, this with this help of amendments, okay, the provisions can be modified. Okay, and there are various provisions which have already been modified number of times. Okay, we don't know again where the Ministry of Corporate Affairs may come up with the provisions of the again the common seal, okay, which should be made mandatory again. Okay, so now as per this Amendment Act, any two directors normally along with the company secretary, if appointed, okay, so they can sign on the document and that may become a valid document. Okay, many of the times, okay, these particular tasks can be sub-delegated, okay, with the help of power of attorneys. Okay, so in some cases the power of attorneys are entered into, but it should be done properly with by the authority only. Okay, so CS appointment is made mandatory, has been made mandatory where the company's paid up capital is more than 10 crores. Okay, earlier it was 5 crores, now it is 10 crores. So common seal is very important concept. This concept is also called as signature of the company, because for entering into any particular document you require signature, and company being the artificial legal entity, okay, cannot be held directly liable, and that is the reason some sort of okay identification is required on behalf of the company, and that is what is exactly mean by common seal. So these 3 points are you can just study these 3 points together. So how company can purchase the separate property, how company can own its separate property, or how company can enter into contractual rights with the help of the common seal. Okay, so these are some of the provisions. Let's move further with the topic. Separate property we have already completed. Okay, transferability of shares. Of shares. Okay, what do you understand by this word transferability of the shares? Again, see, to better understand this company form of business, we need to take the reference of partnership business again and again, because partnership firm business is totally based on the agreement between the partners, and that agreement is called as partnership deed. So all the rights, liabilities, obligation, whatever it may be, okay, can be incorporated in that particular document. Now, the partnership business is based on trust, and there are certain restrictions like partners cannot introduce a new partner without taking the consent of existing partner. But that is not the case with the company form of business. In case of company form of business, the transferability of the share is one of the unique feature. It means the shareholders did not ask the other shareholders before transferring their shares. Nowadays, okay, the companies are basically there are classification of companies like private limited companies, public limited companies. In case of public limited companies which are listed on the stock exchanges, those who are doing the trading or those who are having the demat accounts, they must be aware. Transferring the shares is not that tedious task now. Okay, you may just place the buy order or you may just place the sale order and you can buy or sell your transaction in fraction of seconds. It will not take much of your time. The shareholders may get or the transfer of share may just happen. But in case of private limited company, it is not that easy. If the physical share certificates are there, there is a procedure involved for that. SH4 form has to be filled properly. There it is called as share transfer form. Then transferee they will have to sign on that. They will have to pay the stamp duty along. They will have to put everything. Okay. So there can be some restrictions in case of the private limited company, but in case of public limited company, the shares can be freely transferable. So I can make some distinctions over here for your information. So let's assume that it is public limited and here it is private limited. Okay. So in case of public limited, what I mentioned, okay, shares are freely transferable. Freely transferable. Okay, but here, okay, there can be some restriction. It may be restricted. I can just say it may be restricted. Okay, so what does it mean? Okay, so when I say the freely transferability, it means that I will not have to take the consent of other shareholders before transferring my shares. That is not the case with the public limited company. But in case of private limited company, okay, restrictions can be laid down. Let's assume that there are three shareholders, okay, A, B and C. Now A wants to transfer his share to D. We are assuming that this is a private limited company, not a public limited company. Now what is it's too early to say that what is private limited, public limited. Don't worry. Okay, we are going to talk about that later on, the classification of company. Those who are the common students, they will understand private limited means, okay, the private parties are involved, just in the layman's language. Public limited means the shares are invited or shares are issued to the public, or public can become the shareholder in the company. So in case of private limited, that restriction can be laid down. Now what will happen over here? Now A wants to transfer the shares to D. Now, if it is a private limited company, they may have some kind of understanding by which A may be restrained from transferring shares to outsider without taking, or you can say without approaching existing shareholders. Now, who are the existing shareholders? It is B and C. So, if A wants to transfer, then he must, okay, he first has to approach B and C, and if B and C are not ready to purchase the shares of A, then in that case A may go to the outsider and transfer his shares. So such type of restriction can be laid down under articles of association of the company. What is articles of association of the company? Articles are nothing but rules and regulations of the company, which are very important for the internal management of the company. Okay, but this is not the case with the public limited company. In case of public limited company, A can go to D and transfer his shares without first approaching B or C, as the case may be. Okay, so this is a very important feature which makes it very different. Okay, from, you can say, this makes it very different from other features, like from other forms of entities. So because of these particular feature also, I can just mark a star to this feature as well. The company form of business is very popular. I will give you time for writing as well. So far we have discussed 9 features. So let's talk about now the 10th feature, capacity to sue and be sued. Capacity to sue and be sued. What does it mean? Okay, what does it mean? Okay, so you can say that capacity to sue and be sued means a legal proceeding can be initiated by the company or it may be initiated against the company. So when I say capacity to sue means company can initiate legal proceeding in its own name. And here a suit can be initiated, or you can say a legal proceeding, suit, or you can say legal proceedings can be initiated against company. Okay, so this is meant by capacity to sue and be sued. So company can initiate the proceeding in its own name, legal proceeding in its own name. Even the suit can be initiated or legal proceeding can be initiated against the company's name. So if an outsider wants to initiate a legal proceeding, he need not have to initiate that legal proceeding in the name of the shareholders or directors, as the case may be. Okay, it can directly be initiated against the name of the company. Now the question will arise whether company can file a suit against shareholder or shareholder can file a suit against the company. The answer is yes. Okay, that is also possible. Okay, so it is not like that in the case again we will compare this particular situation with the partnership form of business, where partners cannot initiate the legal proceedings against its own firm, against their own firm, partnership firm. But that is not the case with the company form of business. In case of the company form of business, okay, it is very much possible. And there have been multiple examples where shareholders have filed a suit against the company, even the companies have filed a suit against the shareholders. So this is again the one of the very unique features, and there are provisions relating to the civil suit in the Code of Civil Procedure as well. If one has to file a suit, okay, if anybody wants to go in the litigation in future, then you should be aware about this particular provision. Under CPC, there are certain provisions. If one has to file a suit or against the company or on behalf of the company, then there are certain procedures, like suit can be filed, okay, by the authorized representative. Okay, of course it has to be authorized. Okay, normally directors are authorized by on behalf of the company to file a suit. But yes, the express authorization can be given by the board of directors to any specific number of persons. Okay, so this is one of the very important feature. Okay, we are coming to the end of the in post, yeah, limitation of action. Okay, what is meant by limitation of action over here? Limitation of action means there can be limits as okay, the company can draw the limits up to which company may function. Now where the limits can be drawn, where exactly can be there can these limits be drawn? Okay, it is under the memorandum of association. So memorandum of association, basically it is a public document which talks about the object clause. There is one of the very important clause which is called as object clause. Under object clause, okay, the functions of the company can be very well specified. What a company can do and what a company cannot do. So there can be limitation of actions. Company cannot go beyond that. Okay, and if company wants to go beyond that, company first has to change or alter its memorandum of association to that effect. Then only company can proceed further, okay, and act accordingly. And let's talk about the last feature, which is professional management. Professional management. So you can say that professional management, in this particular feature, what I really want to convey is it is very easy to attract professionals, or the company form of business is basically run by professional management, because it is a very structured form of entity. There are various provisions in few companies. In the space for the specified companies, the CEO has to be appointed, company secretary, CFO, they have to be appointed. They should be managing director of the company. There is a board of directors of the company. So there has to be audit committee. The auditors should be appointed, and because of all these checks, okay, or you can say because of all these complicated provisions, the professionals, they get attracted towards the company form of business, which is not the case with the partnership or any other form of business. I'm not saying that professionals may not work with the any other form of entities, but there is always an insecurity involved when they work with the other forms of entities, where the liability is unlimited. If due to the unlimited liability, if anything goes wrong with the owner of that particular entity, then their business may come to an end. But that is not the case with the company form of business. Though company is going for the insolvency, I can give you the examples of the companies which are there in the pipeline of insolvency. But till the final, okay, winding up procedure is done, till that time also company's business or company's employees may work with that company. Okay, if directors are no more, shareholders are no more, if this point can be connected with the perpetual succession, then also, okay, professionals, they may continue to work with the company. Take an example of the Satyam Limited. The fraud was happened, okay, there were 55,000 employees who were working at that time, but still when the Tech Mahindra took over the Satyam, okay, all those employees were absorbed to some extent. Okay, so they continue to do the work with the company. So though the original, the promoters were not there later on, so they were prosecuted. Okay, so all these things, okay, make a company a unique, or you can say a very popular form of entity in comparison to the other forms of business entities. So these are some of the features. Very quickly you can just write down, very quickly you can just go through these features once again, and you can write down these notes, running notes, for your reference. So So let's quickly revise what we have done. We have talked about corporate personality, or it is also called as separate legal entity. Okay. So we have studied the two case laws. Okay. In this particular point can be asked as a short note as well. So make a note of it, or it can be asked as a 12 marks question. So last time we have discussed in detail the various theories of corporate personality. Last time we have discussed Solomon versus Solomon and Company Limited in detail. This time I have added one more case over here, Lee versus Lee's Air Farming Limited, 1961. Then we talk about artificial legal person. Company is an artificial legal person which is different from the natural legal person like us. So we have discussed about the case of Union of India versus Khadar International and other 2001. Please make a note of all these particular points. I give you 1 minute to write down everything. I hope you have made the notes. Yes. Let's talk about, let's quickly revise the next topics. Company has nationality, but it is not a citizen. It is not a citizen. It may have nationality, like it can be treated as the Indian company. It can be called as Indian company, but it is not a citizen. Very important feature we discussed, that is limited liability. Liability is limited, can be limited. See, try to understand, limited liability does not mean that all companies will have limited liability. It can be by guarantee, liability by a guarantee, or unlimited liability. Okay, that the shareholders decide. But in most of the cases you will find, okay, shareholders they prefer to go for the company form of business because of this concept, limited liability. So we have discussed one of the example, okay, where the 1000 rupees he is holding, the shareholding 500 he has already paid. The balance amount is 500 rupees, which is called as called up capital, which he can pay, okay, in case the liability will occur. So his liability will not be exceeded, okay, beyond 1000 rupees, okay. Then we talk about very important again concept, that is perpetual succession. Perpetual succession means going concern. Okay, company, okay, may not die, okay, if the shareholders, okay, because of the death of the shareholders or directors. Make a note of all these points very quickly. I hope you have made the points. Separate property, company may own or dispose of separate property. Company may own or dispose of. I can just add one more point. Company may own or dispose of property. Okay. So company can have its own property in the name of the company. There can be contractual rights in the name of all these points are interconnected. Contractual rights, company can enter into a contract as per the Indian Contract Act 1872. Company can have its own signature, that is common seal, because while entering into all these transactions, company may require the signature, that is a common seal. Normally now as per the Amendment Act, okay, 2 directors plus CAs if appointed, they can just verify the document, okay. Transferability of the share is one of the very important feature we have discussed, okay. I have given you example of public limited and private limited company. In case of public limited, it is freely transferable. In case of private limited, it can be restricted. With the help of this example, okay, I have discussed. Please make a note of all these points. And the last three features, company capacity to sue and be sued. So company can file a suit in its own name, or a suit can be filed against the company. So all these points I have noted down over here. Just write down that. There can be limitation of action which can be given under MOA, that is Memorandum of Association. So MOA is very important document which talks about the objects of company. Okay. Professional management. Company is basically run by the professional management. Professional, they gets attracted towards the company form of business because it is a very structured form of entity. Okay, just make a note of all these points. I hope today's session you will have learned something new. Okay, the important topic which can be asked for the 12 marks or the 5 marks. This question has been asked multiple times, and separate features also have been asked multiple times as a short note or the 12 marks full length question. So that's it from my end in today's session. Okay, thank you so much for attending this session. Goodbye.